Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Traveling to meet a minor lawyer, Chicago, Illinois. Being charged with traveling to meet a minor in Chicago, Illinois is an extremely serious situation with potentially life-altering consequences. These cases can involve felony charges, significant prison time, mandatory sex offender registration, and long-term damage to your reputation and future. If you've been accused or arrested, it's critical to understand that the stakes are high and that early legal intervention can make a significant difference. At Combs Waterkotte, our experienced criminal defense attorneys understand the complexities of Illinois laws surrounding traveling to meet a minor charges. We work quickly to analyze the facts of your case, challenge the prosecution's evidence, and begin building a strong defense strategy tailored to your circumstances. If you're facing traveling to meet a minor charges in Chicago, don't wait. Call 312-500-HELP today to protect your rights and start your defense. Traveling to meet a minor lawyer in Chicago, serving all of Cook County. Facing a traveling to meet a minor charge in Chicago or anywhere in Cook County can feel overwhelming, especially given the serious penalties involved. The consequences of a conviction can extend far beyond the courtroom, impacting your freedom, career, and personal life. You need a defense team that understands what's at stake and knows how to respond effectively from day one. At Combs Waterkotte, we bring more than 8 decades of combined criminal defense experience to every case we handle. Our attorneys take a strategic, detail-oriented approach, carefully examining digital evidence, law enforcement procedures, and the circumstances surrounding your arrest to identify weaknesses in the prosecution's case. We prioritize clear communication and a client-focused experience, so you're never left in the dark about your case. Our attorneys even have Secret Service National Computer Forensic Institute training and understand how prosecutors use digital evidence against sex offenders. We use this knowledge to help build your defense. From negotiating for reduced charges to preparing for trial when necessary, our goal is always to secure the best possible outcome for you. If you're ready to take action and protect your future, contact Combs Waterkotte online or call 312-500-HELP today. The sooner you have an experienced defense team on your side, the stronger your position will be. What is traveling to meet a minor in Chicago, Illinois? Under Illinois law, there's usually a progression of offenses involved in traveling to meet a minor cases. The first offense involved is typically grooming, the act of communicating with a child in order to entice them. Next comes indecent solicitation, or knowingly asking a child to perform an act of sexual penetration or sexual conduct. Eventually, these actions result in an individual attempting to meet up with a child, an offense that Illinois refers to as traveling to meet a child. 720 ILCS 5/11-26 defines the offense as follows: traveling any distance within Illinois, to Illinois, or from Illinois, for the purpose of engaging in a sexual offense as defined in Illinois' Sex Offender Registration Act, after using electronic messaging or other means to seduce, solicit, lure, or entice a child under the age of 17. Since the statute mentions it directly, it should be noted that some of the most common sex offenses included in the Illinois Sex Offender Registration Act, SORA, include child pornography, indecent solicitation of a child, sexual exploitation of a child, Criminal sexual assault, aggravated criminal sexual assault, predatory criminal sexual assault of a child, criminal sexual abuse, aggravated criminal sexual abuse. SORA also covers the following abduction-related offenses with respect to performing a sex act with or sexually assaulting a minor: kidnapping, aggravated kidnapping, unlawful restraint, aggravated unlawful restraint. Finally, Illinois's attempt law asserts that even the attempt to meet up with a minor can result in criminal charges. This applies even when a meeting does not actually take place or if the offender winds up meeting with an undercover police officer. What are the penalties for traveling to meet a minor in Chicago? Traveling to meet a minor in Chicago, Illinois is a Class 3 felony offense. A conviction for traveling to meet a minor can result in a prison sentence between 2 and 10 years, depending on the severity of the defendant's actions. On top of that, a conviction requires joining the Illinois Sex Offender Registry. 730 ILCS 150/2 defines individuals convicted of traveling to meet a minor as sex offenders, and 730 ILCS 150/7 requires that they remain registered for at least 10 years. If convicted, individuals may run into trouble applying for housing in the Chicago and Cook County area. 720 ILCS 5/11-9.3 bars convicted sex offenders from living within 500 feet of a school or park, and 720 ILCS 5/11-9.4-1 says convicted sex offenders must remain outside of schools, parks, and childcare facilities altogether. A conviction for traveling to meet a minor may also result in lost employment opportunities. Chicago employers tend to run background checks, and a conviction for a child sex offense may see your application automatically disqualified. What to do if you're arrested for traveling to meet a minor in Chicago? Traveling to meet a minor is a very serious charge, and if you're arrested for it, it's vital to understand and assert your legal rights. The criminal defense lawyers at Combs Waterkotte urge anyone arrested for traveling to meet a minor in Chicago to do the following. Exercise your right to remain silent at all times. After an arrest by the Chicago Police Department or other Cook County law enforcement, do not answer questions without an attorney present. Investigators often attempt to gather statements that can later be used to prove intent, which is a key element for a traveling to meet a minor charge. Politely but firmly invoke your right to remain silent and request legal counsel. Contact a Chicago criminal defense attorney immediately. If you are arrested in Chicago for traveling to meet a minor, your first step should be contacting a defense attorney familiar with Cook County courts. These cases are often prosecuted aggressively by the Cook County State's Attorney's Office, especially when they stem from online sting operations. An experienced Chicago defense lawyer can intervene early, protect your rights during questioning, and begin building a defense strategy tailored to local court procedures and prosecutors. Avoid contact with alleged victims or undercover officers. In Chicago-based cases, courts often impose strict no-contact conditions as part of pretrial release. This includes any communication with the alleged minor or undercover officers involved, if the arrest was a result of a sting operation. Violating these conditions in Cook County can result in immediate bond revocation and additional charges. Follow all court orders carefully and allow your attorney to handle any necessary legal communication related to the case. Be aware of sex offender registration consequences in Illinois. A conviction for traveling to meet a minor in Chicago will likely require registration under the Illinois Sex Offender Registration Act. This carries long-term consequences, including public listing and residency restrictions that are especially challenging in densely populated Cook County. Understanding these potential outcomes early can help guide decisions about your defense strategy and whether to negotiate or fight the charges at trial. Preserve evidence from phones and online accounts. Many traveling to meet a minor cases in Chicago rely heavily on digital evidence, including text messages, chat logs, and social media communications. Do not delete or alter anything on your devices after an arrest, as this can lead to obstruction charges. Instead, inform your attorney about all relevant accounts and communications so they can properly review the evidence and potentially challenge how it was obtained. Follow all Cook County court dates and conditions strictly. Missing a court date or violating release conditions can result in a warrant for your arrest and additional legal trouble. Cook County courts expect strict compliance with all orders, including electronic monitoring or check-ins, if imposed. Stay in close contact with your defense attorney and keep track of all scheduled appearances to avoid compounding the charges you are already facing. Criminal defense strategies against traveling to meet a minor charges in Chicago. While traveling to meet a minor is a serious charge in Chicago, a good defense attorney can still help. At Combs Waterkotte, we've handled several Chicago child sex cases, and we've found the criminal defense strategies below to be effective in achieving acquittals, charge reductions, and dismissals. Challenging intent. One of the most effective defenses in Chicago, traveling to meet a minor cases, is demonstrating a lack of intent. Under the law, prosecutors must prove the defendant traveled with the purpose of engaging in unlawful sexual conduct. In Cook County courts, defense attorneys often argue that conversations were ambiguous, exaggerated, or never meant to lead to actual conduct. Without clear intent, the state's case can weaken significantly. Entrapment in Chicago sting operations. Entrapment is a common defense in Cook County cases involving undercover officers posing as minors online. If Chicago law enforcement induced or persuaded someone to commit an offense they otherwise would not have committed, this defense may apply. Courts in Cook County closely examine whether the idea of a meetup originated with police or with the defendant. If officers cross the line from investigation to persuasion, the charges may be challenged. Presenting an alibi defense. Although less common in these cases, an alibi defense may apply if the defendant can show they were not actually traveling to the alleged meeting location. For example, if location data, surveillance footage, or witness testimony places the defendant elsewhere at the time of the meetup, it may undermine the prosecution's claims. Establishing that the defendant never took a substantial step toward meeting with a child can weaken the charge. Arguing lack of the presence of a real minor. In many Cook County prosecutions, there is no actual minor involved. Instead, the minor was an undercover officer. While Illinois law allows charges based on belief, defense attorneys may still challenge how convincingly the minor was portrayed by law enforcement. If communications were unclear or inconsistent, it may raise doubt about whether the defendant genuinely believed they were communicating with a child, which is critical in Chicago prosecutions. Challenging digital evidence and online identity. Traveling to meet a minor cases in Chicago often rely on usernames, IP addresses, and online profiles. Defense attorneys may question whether the defendant was actually the person communicating with the alleged minor. Issues like shared devices, hacked accounts, or misidentified IP addresses can create reasonable doubt, and in complex digital cases, undermining attribution can be a key strategy. Suppressing evidence under the Fourth Amendment. In Chicago, traveling to meet a minor cases, Digital evidence like text messages and chat logs is often central to the prosecution. A defense attorney may challenge how this evidence was obtained. If the Chicago Police Department or other agencies conducted an unlawful search or seizure, Cook County judges may suppress that evidence due to Fourth Amendment violations. Without those key communications, the prosecution may struggle to prove intent or criminal conduct. Invoking Fifth Amendment protections in Cook County. Statements made during or after arrest can heavily impact a traveling to meet a minor case in Chicago. The Fifth Amendment protects against self-incrimination, and Cook County courts may exclude statements obtained improperly. If law enforcement continued questioning after a defendant invoked their rights, those statements could be suppressed. This can significantly limit the prosecution's ability to establish intent or confirm incriminating details. Miranda rights violations in Chicago arrests. Closely related to Fifth Amendment protections, Miranda violations can be a powerful defense in Cook County. If Chicago police failed to inform a defendant of their rights before an interrogation, any resulting statements may be inadmissible. In cases where prosecutors rely heavily on admissions or explanations, suppressing these statements can dramatically strengthen your defense. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.